Welcome back. You're watching HFO TV, co-sponsored by AMF Capital, the Ball Janik Law Firm, the Butler Exchange Group, and the construction firm J.R. Johnson.
Welcome back to HFO TV. I'm Greg Frick, partner at HFO Investment Real Estate. Thank you again for joining us in another teleconference meeting since we are in about 90 days now in this COVID pandemic. So we're lucky enough to have Brad Kraus at Warner Allen. We're going to talk a little bit about kind of some of the nuances with doing maintenance and things with during COVID. And for people who don't know, Brad and Warner Allen law firm are specialized in landlord-tenant law. So you guys have been around for years. We've had a lot of clients use you guys for various, services and things like that. So thanks again for taking time out today to kind of educate the market a little bit about some of the nuances.
Appreciate it. Thanks for having me.
So I know, things are a little different now with COVID in place. We're filming this, close to the end of June. So it's been in place for, close to 90 days now. What do you, for your clients, again, you have a lot of management and individual owners. How are they dealing with some of the changes in their business that COVID has kind of brought along, more with kind of the existing tenants and dealing with maintenance and things like that?
Well, the difficulty lies in the safety aspect of things.
Right.
And that's really what we're trying to really focus on is a lot of the health and safety guidance that we've been getting from the federal government, from our own state government. You can incorporate that into how you're working your business, and that's really the overarching theme. The obligations of a landlord don't change even in a pandemic. So you try to incorporate the guidance that you're getting, while at the same time continuing to maintain every obligation that you have to keep your tenants happy, keep them safe, and keep their premises habitable.
And I know I've talked to a lot of owners and clients and have said when this first came out, kind of having their maintenance staff do a lot of stuff on the outside of the building, all kind of the spring and summer projects have all been addressed, but now we're into it now where now there's things coming up. You've got, people that have been staying in their units longer, they're not going to work. Routine maintenance, getting into units. What's your kind of recommendation? I've got a tenant that is having an issue. Is it just making sure the maintenance people go in suited up? Are you asking the tenant to leave the unit? Kind of what's your, how would you advise somebody if they called you and said, hey, Brad, I've got a tenant that wants some maintenance work. How should I handle this?
Yeah, so a couple of different things to keep in mind. First, a conversation is always helpful. So being open, being cordial with your tenant, making sure that they're comfortable with how you're approaching things, that's a great first step. Because keep in mind, there's nothing that requires the tenant to leave when you're doing maintenance. They can be there if they want. So if there's a time where you want to go in and they say, no, I'd like to be here for that, they're entitled to do that. Remember, under the entry statute, they can deny entry. They just can't unreasonably withhold it. So a conversation and working with them about the time that works best for them and how they want to approach that maintenance issue is a great first step. If they do want to be there, obviously having your folks mask up, glove up is another great step. Keeping everybody away from each other. Generally speaking, most of the time, you're not going to need to be within 6 feet of your tenant to address a maintenance issue. So that's another thing that I've chatted with my clients about. Make sure that your tenants know, social distancing, 6 feet apart at least. If your tenants aren't wearing a mask, having your maintenance folks maybe bring another one. Not a bad idea, because if your tenant doesn't have a mask or isn't wearing one, you can say, would you mind putting this on just so we can kind of keep apart, keep the social distancing. Another, great step there. Really, the overarching theme is conversation, making sure you're complying with with that health and safety guidance, and also keeping in mind that the health and safety of your maintenance staff is also important. So if there's a situation where a tenant is not, let's say, keeping everybody's safety in mind, your folks have the right to leave. They do, and come back later. And if that's not respected, that's an entirely different situation.
Got it. And then what are you seeing? I mean, what are some of these situations where you've, like you said, the tenant you can make the request to go in, they're not obligated. I mean, this is kind of not just specific to COVID. At what point does a property owner have the ability, I can post once, they say, no, can I go in, if it's, again, for maintenance or things like that, how does the nuances of that?
Yeah, and the interesting part about that is a couple of years back, my firm litigated one of the biggest landlord-tenant cases in Oregon in terms of how much it cost in terms of attorney's fees. That case was Willamette Landing versus Burnett. And that case was actually based upon a denial of entry situation.
Okay.
My client wanted to go in, make some repairs, and the tenant just continued to deny access, deny entry. And it spiraled into large-scale litigation with attorney's fees that were over six figures, let's say.
Wow.
We won that case. We prevailed. We got all of our attorney's fees in the attorney fee award because we set up a situation where with the denial of entries, you have to set it up. It's not just a situation where the tenant denies you access one time and you get to serve them a notice. The statute expressly allows them to deny you access. So it's almost something in that case. I think there was I can't remember the facts correctly, but I know it was over 3 times where they tried to gain access, sent multiple correspondence after those denials saying, hey, we're entitled to access. You've denied us access, really papering that file, documenting those denials. Once you have a sequence and a series of denials, then you can start working towards a notice of termination for cause. That's what happened there. The cure period, right around the cure period in that notice, is when they tried to go in again. At that time, the tenant denied access again. And if memory serves, that's what we filed the FED on, and that sparked everything.
I mean, I'd hope on an access, asking for access, that you wouldn't have to go that many times. I understand once or twice, but that's always a question that's come up. And now with COVID, the thing is as we've talked about, is you've got a tenant that's to say, I've got repair that needs to get done. What are the procedures? I've heard some management companies ask for the tenant to be in another room. We'll come in at this time, and we would appreciate it if our maintenance crew could come in and you could stay into the separate room. I mean, is that an unreasonable ask, or those things? Again, I think a lot of it you brought up is communication on the front end.
Yeah, and I don't think that's an unreasonable ask. The problem with that sort of thought process is, remember, we're sort of bound by what's in the statute, and it's not as if the statute says anything about a pandemic or anything about how we handle this. So we're sort of left with the tenant can't unreasonably withhold access. That's the standard that we have. And does the tenant's refusal, let's say the tenant refuses to go in the other room, right? Does that refusal, A, in and of itself constitute a denial of access, and B, is that unreasonable? We can have a back and forth, and I'm sure tenants' attorneys would agree with me on that, or not agree with me. They disagree with me on that. But it's really up to the judge or the jury as to what is unreasonable. And obviously, COVID presents a series of issues that none of us know how they interplay with the Landlord-Tenant Act. The best thing that landlords can do to counteract that uncertainty is A, continued efforts to try and take care of the problem, and B, papering the file, really having that open communication, that communication in writing, right? Not just verbally, because when it's in writing, it's very clear what you're asking and how you're asking it, right? If I'm just saying, hey, we want to come and take care of something, what's the best time that works for you? It shows that you're trying to make an effort to revolve around that tenant's schedule, to revolve around their needs, their desires, perhaps their health risks. And that goes a long way. And that's the only way I can frame that in a pandemic world is really being open and honest, really being cordial about it. And if the tenant is being difficult on that front, hey, I'll litigate that all day. I'll stand in front of a judge and say, my client tried their hardest. They were acting in good faith, and they continued to get stonewalled.
And does it make a difference if this request is for, maintenance versus a a lender request to get into some, I mean, do the courts look at that differently, or is it the same thing as long as you're, like you said, asking, being respectful, the kind of the normal things, but does it, I understand if, tenant says, hey, I've got, water coming out of my sink, that's a different deal, that's a kind of emergency, but is there a difference between general maintenance, so to speak, and a lender required inspection? Because that's, from our standpoint, that's an issue that we've had in due diligence. I've got an appraiser that needs to get into 25% of the units. So, how do we handle that? I'm curious kind of what your take is on that.
Yeah, I think they're all the same.
Okay.
I don't look at them any differently. Obviously, the issues that arise from not being able to get access are separate and distinct, right? If you have to have some inspections related to lender issues, you may be damaged in some way by not being able to do that timely.
Right.
And the way that you counteract that is sending your tenant letters, letting them know, hey, we will be damaged if you continue these denials. And those damages, remember under the entry statute, the landlord is entitled to seek damages and injunctive relief if the tenant unreasonably withholds access. So
Okay.
that's sort of what you're setting up there. On the flip side, when it comes to maintenance issues, if maintenance isn't taken care of and it presents a habitability issue, obviously the tenant is able to claim that the premises is diminished in value. But if the landlord is trying to make those efforts and address those issues, then that cuts off the tenant's right to damages for that lack of, or that diminution in rent, so to speak, right? If we're trying to take care of something and you're not letting us, you don't get the benefit of that being difficult. So really, I look at them the same. It's just a matter of where you're fighting that battle.
Are there any other kind of complex issues that are rising out of this? We've talked about rent, we're all in the middle, special sessions going on, or short sessions going on right now in terms of rent deferral and all that. In your world, because you guys are right smack dab in the middle of, landlord tenant, laws, what do you see on the horizon, or what's keeping you up at night in terms of, this?
The one thing that I've heard that I haven't had any clients come to me about is, a tenant suing for potentially, allegedly catching COVID in the building. That sort of case, maybe a negligence case, something like that, where the tenant sues for that bodily injury, and now you're facing, a $500,000 claim, something like that, related to personal injury. Let's say somebody catches COVID and potentially, their immune system's not great, but they pass away, right? That's the nightmare scenario. The problems with such a case obviously would be, in order to prove negligence, you would have to prove, that there was some causation there, right? Something that the landlord did caused that injury to the tenant. And that's a tough sell, just given, what COVID is. And obviously, as we hear in the world, there's people that are, giving off the coronavirus and they're asymptomatic. So where that causation piece would fit in, I think that would be a difficult sell, but I have had some clients ask me about it. My opinion is, I don't foresee it as a huge issue, but again, anytime you're facing a hefty lawsuit like that, it does cause you some concern. But that's the one thing that I'm thinking of. Obviously, the issues that are going down right now in Salem, we'll see what they enact, and we will deal with that as it comes. That's the best I can say about that. I don't have many positive thoughts on the bills.
But yeah, I know on the liability side, I know there's been a lot of talk from, not just in our industry, but a lot of industry groups here in the state saying, there needs to be some kind of, if we're going to open up and, from employers, and there needs to be some kind of standard set from that. I know they're trying to do that on some of the public entities, let's do it on private. So as I've talked to some people in our industry, said, maybe that, well, I'm very concerned about that as well, but that may be a message that can get delivered by, the other industries, and we need to concentrate on, from a legislative side, of the moratorium and how we're doing with deferment, and how do we get people that really need help get some kind of assistance that gets to the property owner so that, the system money can get in the system. So
it's unfortunately landlords are sort of, they're dealing with the brunt of everything right now.
Yeah.
It almost seems like our elected officials are saying that landlords can take the brunt of this entire financial collapse, so to speak. From my opinion, the people that need help deserve help. The people that are negatively affected by COVID, they deserve that help, and they should get it. I don't think it's a huge ask to have somebody present evidence that they have been affected. I've had multiple clients, basically tell me that they've had tenants that have just said, we're not paying rent, and they haven't been affected by COVID. They haven't lost their jobs. It's just they don't feel the need to pay rent right now. Whether that be because they feel that there's some sort of rent waiver that's needed. You've heard a lot about the waive the rent strikes and things like that. Whether they feel like that is the grounds for which they say they're not paying rent, or it's just simply, I've had a case here recently where, the tenant knew that they were going to be leaving the country. So they just didn't feel the need to pay anymore, because it's not as if we can hunt them down when they leave the country.
Right.
That situation does not deserve, it doesn't deserve that protection in my eyes.
Well, we tried to explain to people when you have, I was the councilwoman in Olympia, Washington, saying, she was going to make a political statement by not paying her rent, and trying to explain that by you doing that, and basically is hurting people that really need help. Because like you said, majority of the landlords or property owners are going to do some, help when they can and do an assistance. But when you have people taking advantage of the situation, it really limits the ability for people that need help to get that help. And it's kind of sad that, like you said, in Oregon, legislative-wise, it's kind of been, let's just pile on the property owners and let them take the brunt of this thing, as opposed to bringing it broad-based to all societies. So
it's also sad that there's not a realization that, I think I saw a study recently that I think 50% of the rental units, I think, are owned by smaller mom and pops. Something along those lines. There's almost this misconception that a lot of the rental units, or all of the rental units, so to speak, are owned by these big multinational companies that have, billions of dollars just sitting there that they, have in a room somewhere that they can, just do whatever they want with. And that's not true.
Right.
Small mom and pops, they can't miss a rent payment for 2 months, 3 months.
Exactly.
They have bills to pay too.
Right.
And I don't see enough concern for those folks. Those folks are small business owners.
Yep.
Those folks deserve protection. They need protection. Otherwise, you've seen what's happened in Oregon. Businesses are closing, restaurants are closing, small businesses they can't take the brunt of this.
Yeah.
And so you wonder how folks like that are going to come out of this, if they're going to come out of this. And that's the sad reality of COVID, is it's not, you're not hurting the big multinational companies, you're hurting the smaller mom and pops.
it's going to be hard to get through this when you're pointing blame and, putting the burden on one segment versus, everybody's going to have to take a little bit of a hit. And I think, that's really bad. Well, I want to thank you for taking the time to come do this again. If people have questions, you can reach Brad at the website below. Again, we've got a lot of clients that have used their firm for years and years and years on some of this landlord-tenant stuff. And again, thank you again. Hope you and the family are safe, and we'll be talking to you soon. Thank you.
Thanks for having me. Take care.
Yep. Thanks again at HFO TV. We'll see you next time.
Our entire office specializes in multifamily real estate, making HFO the largest multifamily brokerage in the Pacific Northwest. Your success is our passion. Build your legacy with HFO. Call 503-241-5541 or visit our website at hfore.com for more information.